Smokable hemp is basically off the store shelves in Texas, and now a lawsuit filed this week in Travis County is trying to undo that. I'm Nathan Bernier with KUT News, and we're going to talk to a lawyer who's involved with this lawsuit, who's involved with trying to sue the state to stop these regulations, which these rules are really completely upending the market. In case you're not familiar, you probably know most of this already if you're listening to this video, but the state legislature passed SB 3 last year. That was a piece of legislation that essentially would have completely banned all THC products in Texas. And that that bill was vetoed by Governor Abbott. And he told lawmakers, go back, hold special session, and come up with regulations, not a total ban. Well, lawmakers could not agree. They reached a stalemate. They could not agree whether to ban or regulate. So after 2 special sessions, they went home. And then Governor Abbott issued an executive order to the Department of State Health Services saying enact some regulations. And he listed some very specific rules that wound up becoming regulations, different from laws. These are not adopted by the state legislature, and that's a very important point in this lawsuit. So December 26th, Department of State Health Services issued its proposed rules. There was a hearing in January. There's a lot of comments provided back to the Department of State Health Services saying these rules go too far, change the rules. Other people are saying these rules don't go far enough. You need to increase the age limit to 25 or, basically regulate these businesses out of existence. So then the Department of State Health Services in March came back and said, okay, here are our adopted rules. These are the final rules. The formal email went out to hemp manufacturers and retailers March 11th saying these rules are going to take effect March 31st. So it was a 20-day period, a very relatively short period of time for these companies to come into compliance with these new regulations, which include, for example, fees that go from $150 for retailers per location per year to $5,000 per location per year. For manufacturers, it went from $250 a year to $10,000 a year. And one of the biggest changes, which consumers are very well aware of, the Department of State Health Services issued a total THC rule. Now, that requires just a bit of background explanation. For those who are unaware, cannabis is the plant, and hemp and marijuana are legal categories. And the thing that separates hemp and marijuana is the amount of Delta-9 THC by dry weight. Delta-9 is the main ingredient that gets people high, not the only cannabinoid that gets people high, but that's the one that they chose for this metric, 0.3% by dry weight. Delta-9 THC. Less than that, it's legal hemp. More than that, it's legal marijuana. That's what the state law says. The Department of State Health Services introduced this total THC metric, which includes something called THCA, which converts to Delta-9 when heated or smoked. And that's how people have been smoking cannabis in Texas legally, is by purchasing hemp that has low levels of Delta-9, under 0.3%, but significantly higher levels of THCA. And it's the same thing if you go to states where marijuana is legal. If you purchase like bud, most of that Delta-9 when it's smoked is going to come from the THCA. So the smokable products market, segment of the hemp market in Texas, accounts for well over half. One economist I spoke to says it's really over 2/3. And I'm going to post an interview with that guy on my YouTube channel, Robin Goldstein. He's an economist at UC Davis. He studies cannabis markets. He actually lived in Austin for like 4 years, a while back in the earlier 2000s. But let's jump into our interview now with Andrea Steele of the Banks Law Firm in Houston. And I just began by asking her, to explain what this lawsuit is all about.
This lawsuit is about the state agency going beyond its authority and putting in place rules that go beyond what it's allowed to do, and in doing so, they actually conflict with what's permitted by the statute. So it's a separation of powers lawsuit. It has to do with the legislative branch creates the law, the administrative branch carries it out, and the judicial branch interprets it. And so our administrative branch has made it. Our legislative branch already made decisions about the consumable hemp program in Texas. The administrative agency is supposed to carry it out within the framework that's set before them. So in this instance, and it's not the only instance because we've got the prior lawsuits, but in this instance, the Department of State Health Services went beyond its authority in issuing some of these rules. Not all of them. And I think it's really important to also stress that we're not challenging all of the rules. We are challenging only the rules that we believe go beyond the agency's authority. So the age coding, the packaging and labeling, the child resistant packaging, the consumer safety mechanisms, the record keeping, all of those we're not challenging. We are happy as an industry to invite those type of regulations. What we are challenging is the compliance threshold switching from Delta 9 THC to total THC. We are challenging the explosion of fees that are not only for licensing, but also ownership changes and delinquency fees that went from $150 and $250 to $10,000 and $5,000, and the delinquency fee went from $100 to $1,000. So if you're late on renewing your license, it's now $1,000. So these are penalties, not really fees. That they operate as a penalty, they operate as a tax. And then also there's in the rules, there's some compounding penalty structures so that every single day and every single violation just kind of compounds on top of each other. But the statute requires that we have a notice and opportunity to cure. And so by compounding the penalty structure, you take away the statutorily provided ability to have a notice and opportunity to cure any administrative penalties.
Right. So the penalties go up so fast, you're saying, that it makes it very difficult to cure, which is, I guess, does that just mean resolve somehow, some other way? Right.
So let's say you have a labeling issue. You may have to just put another label on it, but let's say that labeling issue has been in place for however long or whatever the case is. And they could theoretically, under this rule, hit you with every single one of these violations every single time or every single transaction. It just depends how they are going to view it. But by compounding it, you exponentially increase the potential without even having had somebody giving them the opportunity to cure it before it compounds. Now, back on that total THC compliance shift, that has cascading effects, right? So, we'll talk about what happens to the farmer, to the processor. And then throughout the rest of the manufacturing supply chain, those acids and the neutral compounds and the acid compounds are going to fluctuate throughout processing and so on and so forth. So we have our Delta 9 standard all the way through, and we have our Delta 9 standard for the finished product, which is compliant not only with the federal definition of hemp, but also our Texas Hemp Plan. And we will talk about our Texas Hemp Plan, but our Texas Hemp Plan includes not only the agricultural provisions, but it also includes the consumable hemp statute, and it includes the agricultural rules. So being consistent with Delta 9 is actually consistent with our Texas Hemp Plan on the finished product side. So, we're challenging the things that that the agency changed by rule that has been set in place by legislature. And because the legislature drafted this statute a certain way, it drafted it in a way that allows for a coherent supply chain to function. There are ways that some people can rely on somebody else's, test, like a Texas grower, a Texas processor is allowed to rely on a Texas grower's compliance test to satisfy the compliance threshold. Texas manufacturers are required to provide full panel testing to Texas retailers. These things are already built into the statute, and we have finished product testing required in the statute that says if your finished product is full panel tested essentially and it meets the Delta 9 threshold, you don't have to test every single ingredient. You don't have to, if the finished product, and that's because in a typical supply chain, not everybody can trace it back to the original source. And so there's this statutory allowance that allows you to have a way to put a product to market, but maybe you haven't been able to trace all the way back to the source, so long as it's safe, right? And it's full panel tested. You've got the heavy metals, the pesticides, if that's appropriate at that stage. You've got residual solvents, if that's appropriate at that stage, microorganisms and toxins. So there will be a full panel test that allows, under the statute, put something to commerce. But the rules change that and make you have additional testing mechanisms throughout the process that will not coherently function during the manufacturing process of cannabis and hemp.
Right. Yeah. And Bruce, my rudimentary understanding of this too is there's limitations, or rather restrictions, on importing certain products that are used, importing them from out of state that traditionally have been used that aren't made by a lot of companies around the country.
Right. So we have statutory protections for being able to retail out of state consumable hemp products that were manufactured somewhere else. And they're required to, be compliant with laws and the statute. And so that's Delta 9. But the rules now change that to total Delta 9, which means not only can you not import the finished products, you also aren't going to be able to import the crop because, like I mentioned before, the crop is going to naturally have that decarboxylation because it's requiring these testings at these different levels. It blocks a grower and a producer from being able to get to the processor because the processor now has to retest. So it conflicts with the statute in a way that makes it irreconcilable.
There was also something in there which I was less familiar with, having to do with a complaint about how the rules were adopted, that claiming that the regulator, the Department of State Health Services, did not take a close enough look at the impacts to the economy or less burdensome alternatives.
Yep. So that's part of it that goes into it, because if you recall, the fee to be a retailer was $150. To be a manufacturer was $250. It went up to $5,000 and $10,000 respectively. And it's per location in Texas that any of these things are happening. If you're a retailer, it's your website. If you don't have, a brick and mortar. So that compounds the penalties significantly. And let's kind of take it back again. This will go into part of the history with it. When we had a very long hearing before the Senate State Affairs Committee hearing, it was like 12 hours long during the legislative process. Right after that hearing, the senator that authored the bill turned around and put in several amendments, including an increase to the fees to go up to $20,000 and $25,000. So that got inserted into SB 3 before the end of the legislative session. SB 3, as we all know, ended up getting vetoed. I don't recall if those fees made it all the way through to the bill that got vetoed, but that's where they originated. And so when the first proposed rules came out, they had that $20,000 and $25,000 fee in them. After the notice and comment period, they reduced them down to $10,000 and $5,000, but they never explained why. They never explained how they came up with the number in the first place. What is it supposed to cover, and what are their costs, and what are their anticipated costs, and so on and so forth. And so answer that question, explain why are these fees so high? How does that relate to the administration of the program?
And in the adoption of the rule, they did say that the fees could be revised if they found that the cost of enforcement was lower. I seem to recall something like that. But you all have made the claim here that these fees, as you said, essentially are an unconstitutional tax, right? Because they...
Right, you fix it later after how many businesses shut down.
Sure.
After how much damage has been done.
Now, let me ask you, the THCA topic is a big one for consumers, because this is essentially the total THC rule, the compliance metric, as you said, is what has removed from the market smokable forms of hemp and concentrate. And I spoke to a cannabis economist at University of California, Davis today, who said, by his estimate, flower accounted for about half of the market, and flower plus concentrate was about 2/3 of the market. So really, I mean, that is the bulk of the legal cannabis market in Texas, the hemp market, if you will.
Forget about that other 1/3 though, right? Because there's other products that use THCA that are not necessarily THCA flower. You could have hemp, like fresh hemp leaves or microgreens. You could have THCA tinctures that are not going to further decarboxylate. You could have CBD flower that will test a little bit higher on total THC than just Delta 9 because of that. That's just the nature of it all. It'll be compliant when it leaves the farm, right? That's what we talk about. That it's compliant when it leaves the farm. And then during the process, the THCA is going to naturally convert to some degree. So then we can't have something like CBD flower even, right? So it's not just THCA flower and THCA concentrate. The way that the rules play out in practice, or they're going to kill the entire market.
Now, I think probably most people listening to this know this already, but for those who are unfamiliar, THCA, so THCA converts to Delta 9 THC when heated or smoked, right? And so this
but it's not just heated or smoked, and that's a part that a lot of people don't understand, right? It's kind of why we have this whole notion that it was a smokable hemp ban. It wasn't a smokable hemp ban. It is far more than that. Heat, light, and time also trigger decarboxylation. So that makes sense at the crop stage that you would have post-decarboxylation testing, because when the plants grow, they're going to be a combination of THCA and Delta 9. And the framework at the federal level is you have your official pre-harvest sample, then you have to harvest within 30 days. That pre-harvest sample is what determines compliance at the farm with hemp crops. Once it's been determined, that's what lets it go into the next stage of the market, right? Over to the processor. And so because of the natural decarboxylation that happens over it doesn't, like, hemp crops aren't necessarily going to go straight to the next step in the supply chain as soon as they're harvested. They're going to be stored. They're going to be dried. They're going to be, there's a lot of different things that happen. And during this time period, decarboxylation is going to occur. So the reason for having a post-decarboxylation testing methodology at an agricultural stage is because you're trying to make sure that you're planning for a worst case scenario with your plant in between your harvest test and when it makes it to the processor. So that once it's compliant, the processor can accept it and move on to the next part of the supply chain. What these rules do by changing the compliance threshold to total THC, and it also plays back in, you'll see when Texas made its farm bill in 2019, mirroring the federal farm bill, we went beyond it. I mentioned to you earlier, and I mentioned in the last video, the federal farm bill leaves consumables to the FDA, and the FDA did not step in. The FDA instead said THC and CBD can't be put in food and drinks and put across state lines. So Texas, when it created its farm bill, which was, months later, they had the ability to foresee a consumable market and protect it inside the state of Texas. And that's exactly what they did. So the rules in Texas, and the law in Texas is that consumable hemp products are treated as food, and they fall under the food regime in the state of Texas. Our legislature had the forethought to think, like, nobody else has stepped in right now. Let's step in and make sure we have a consumable market. So they protected it all the way around, and they did it intelligently by making sure the crop was able to get to the next step in the stage, which is to the processor. And it's a total THC at that stage, because you have to make sure that it's not going to exceed Delta 9 later on, right? But that's how it works at the crop stage. And so our legislature accepted it. They recognized it. They wanted post-decarboxylation methodology at the crop stage. They didn't put that in the consumable side.
What does it mean? Can you explain a little bit about the actual process involved here, so that those of us who aren't lawyers can know, like, what the possible outcomes of this lawsuit are? Starting with, let's say, this week, the temporary restraining order request. What is a temporary restraining order, and how soon could it be granted?
So we're asking for three things: a temporary restraining order, a temporary injunction, and a permanent injunction. The temporary restraining order is the first step. That we filed the lawsuit last night. The hearing will be on Friday. I don't think we got the time finalized yet, but it's being worked out. And so that is, basically saying the harm is so egregious that we need a temporary restraining order. Whether there's enough time for the state to have its response built up or not, we just need to get things back to the way they were so the harm can stop accumulating, and we can figure this out in more detail in 2 weeks. So the TRO is like within 3 days you have it and you have your hearing. And if we get the temporary restraining order, then and what we are requesting, like I mentioned, we're not asking all of the rules to be enjoined, only the ones that offend the law. So those other ones will still continue to be in place. So the consumer safety protections, like, we're not arguing about those. So those can continue. But the ones that impact the total THC, the fees, the compounding violations, those are the ones that we're trying to have put on pause until we can really get this better figured out. So the TRO addresses that. Then the temporary injunction will come back in about 2 weeks and have almost like a mini trial. It's another hearing. We will have witnesses, and that's when we will be asking the judge to put in a temporary injunction until we can have a full trial on the merits, because 2 weeks is also not enough time to develop the full case. And so the temporary injunction is there to prevent the harm from continuing while we get it figured out. And then we go through a trial eventually.
But how? Okay, so, right. Yeah. And it might make its way all the way up to the Texas Supreme Court, just like the DSHS regulations about Delta 8.
Same trajectory.
So, right. And I think a lot of folks are not even familiar with the Delta 8 case, which just had a hearing in January. And this was the Department of State Health Services trying to reclassify Delta 8 as a controlled substance, essentially banning it. But that is a temporary injunction that has been in effect for 5 years. So could there be a similar situation here where, say you're granted a temporary injunction, but this case is just unresolved for years and years? And then what happens then?
It could. It happened in the first case. It could happen here. What happens then is, if that's the case, then status quo, we continue to operate as we have been, plus these new consumer safety regulations, right? So we don't have the high fees. We don't have the issue with total THC. We don't have the issue with compounding violations, but we can still get all those consumer safety protections no matter what happens with this lawsuit, right?
There would still be child-resistant packaging and labeling requirements and recall
all
procedures.
Of that still, we're not fighting that. And that's been what the industry's argument the whole time is, like, we don't want to fight you on reasonable regulations. We want regulations. We want you to be able to make sure that consumers have products that they get the products that they're thinking they're getting. What we don't want is the entire market thrown away because the agency went too far. And that's really what happens here. Like, it prevents the supply chain from functioning.
What happens if you don't get the temporary restraining order, if you don't get the temporary injunction? Things still proceed, but with these rules in effect, basically, right? And the consequences that stem from that?
Correct. And so in the Sky Marketing case in 2021, the Delta 8 lawsuit, we didn't get the TRO the first hearing. And so there was a couple of weeks of chaos where people had no idea what was going on. They didn't think that, it was going to be successful. And then we had our temporary injunction hearing and we got the injunction. So, if we don't get it, if we don't get the TRO, I wouldn't be overly concerned. A TRO has a higher bar than a TI. And so if you can't reach the emergency bar of, like, this is like, we got to do it right now, without the state even having a chance to respond coherently, then that's why. So we have it out with the 2 weeks, you get the time. But if we don't get the injunction, then for our lawsuit, those rules still continue, right? They would just continue as they were written. The fees stay high, total THC becomes the metric. However, there are other theories to sue on. And I think that would take place.
And if you are granted a temporary restraining order, does that apply just to the plaintiffs, or does it apply to the entire industry?
It should apply to the entire industry. It will depend on exactly what the order says, but we made the fight for the entire industry.
Okay. Now, the plaintiffs are the Texas Hemp Business Council, Hemp Industry and Farmers of America, and then 8 businesses, right? How did you find the plaintiffs?
So, we've been in the industry for a long time, the ones that are working on this. And so some of these people are clients or former clients or people that we just know from working around the industry. A lot of times, and this would be, a good question to ask for the Texas Hemp Business Council itself, because they have all of their members and the Hemp Industry Farmers of America, because of all of their members, we hear about things. So we know and we hear when something is going to impact somebody, they tell us. And when we hear somebody who has a very compelling story and makes really compelling arguments, we'll look at that. So we've got a variety of retailers, distributors, growers, and manufacturers in this lawsuit, in addition to the 2 associations.
Why does it take so long for these cases to be resolved? Years in some instances, as with the Delta 8 situation.
I don't think most cases take this long. So I think this is a complicated issue. I think it has bipartisan support more than a lot of people realize. So one of the things I think is really important to understand also is we don't have ballot initiatives in Texas. The citizens of the state of Texas don't have the ability to fight and vote for legalization if we wanted to. So we only get granted that through our lawmaking process in our legislature. So what happened with the last legislative process is people of Texas stood up and got very, very, very clear with their lawmakers what they wanted and didn't want, which was why we ended up where we ended up. So I think it's important for everybody to understand that Texas consumers have been demanding access to cannabis for a very long time, and they don't want it cut off. What Texas consumers want is access to reliable, safe, and consistent products, which is what a regulated system will bring. Now, if you institute these rules as currently written with the compliance shifting and the fees, you're going to end up shutting down businesses. You're going to end up driving consumers to the illicit market, which isn't going to have, third-party testing and full panel COAs. We have a really good program in Texas, and we've had one. We've required full panel testing and tracing back to the tracing back to the seed since the beginning of our program. These rules now make that more clear, and I expect that they'll be enforced more than they have in the past. But we really do have a good program here in Texas, and I would love to be able to see it operate in the way that it was intended with consumer safety measures in place.